Today is day 8 of reading files to you about the president each day until people wake up or I run out. Today will be much longer than normal. Let's discuss the dropped lawsuit of Jane Doe / Katie Johnson versus Donald Trump / Jeffrey Epstein. Now, the Jane Doe / Katie Johnson lawsuit against Donald Trump and Jeffrey Epstein stems from 3 separate and distinct court filings made across 2 federal districts. The first is case number 516-CB00797-DMGKS in the Central District Court of California on April 26, 2016 by Katie Johnson and filed pro se, meaning self-filed. Then case number 116-CB06462 in the Southern District Court of New York on June 20th, 2016 by Jane Doe, represented by Thomas Francis Meagher, and case number 116-CB07673RA, also in the Southern District Court of New York, September 30th, 2016 by Jane Doe and represented by J. Cheney Mason and Thomas Meagher. All 3 of these cases were voluntarily dropped by the plaintiff only 3 days prior to the presidential election on November 4th, 2016. The reasons cited? Numerous threats. Let's begin with phase 1. The Katie Johnson pro se filing in California on April 26th of 2016. On the 26th of April, the plaintiff Katie Johnson, who filed as her own attorney, submitted a 6-page complaint in the U.S. District Court of Central District of California, seeking $100 million in damages, naming both Donald Trump and Jeffrey Epstein as defendants. The complaint alleged 4 separate sexual encounters with Trump and 3 with Epstein at Epstein's Manhattan residence during the months of June to September of 1994, when the plaintiff was 13 years old. It also named a material witness, Tiffany Doe, who claimed to have been employed by Epstein for over 10 years as a party planner and to have been present at the alleged assaults. On April 28th of 2016, Reuters reporter David Ingram contacted Epstein's attorney, Martin Weinberg, seeking a comment for a story that was going to press that afternoon. Weinberg then promptly forwarded the inquiry and the complaint to Epstein immediately. On May 2nd, 2016, just 6 days after filing, the California federal judge dismissed the case. The judge ruled the civil rights statute cited did not apply because the plaintiff had, quote, not alleged any race-based or class-based animus against her. The dismissal was purely procedural, meaning that it was dismissed solely on technical grounds, and the court never ruled on the substance of the allegations. Let's move on to phase 2. The New York refiling under the name of Jane Doe, filed on June 20th, 2016. Rather than attempting to refile in California, on June 20th, the plaintiff, now under the alias Jane Doe, hired New Jersey attorney Thomas Francis Meagher and filed a more formal 9-page complaint in the Southern District of New York. Now pause for a moment. I need to give you a trigger warning. Though we have used a few words already, there are quite a few moving forward. And I need you to be aware that if you are sensitive, you may want to stop the video and click like and subscribe if you've made it this far. It does really help the channel. If you are easily triggered though, please take a break from this topic. Though this is important, it can be extremely taxing on the soul. Having said that, the 9-page SDNY complaint was more sophisticated and detailed than the California original. It included claims for sexual misconduct, criminal sexual abuse, sexual acts, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, false imprisonment, and defamation. The defamation claims specifically targeting Alan Garton's April 28th denial, alleging it was, quote, libelous on its face, and sworn declarations from both Jane Doe and Tiffany Doe, as well as requests to proceed anonymously, to waive the statute of limitations, citing ongoing threats, and for a protective order to be put in place. The complaint alleged that on the 4th and final encounter, defendant Trump tied plaintiff to a bed, exposed himself to plaintiff, and then proceeded to forcibly plaintiff, while she, quote, loudly pleaded with defendant Trump to stop. It stated Trump, quote, violently struck plaintiff in the face with his open hand and screamed that he would do whatever he wanted, end quote. Immediately after, Trump allegedly threatened that if she ever revealed anything, she and her family, quote, would be physically harmed if not killed, end quote. The refiling was reported by Global Research and Reader-supported news on July 7, 2016. Now we will move on to phase 3. Cheney Mason joins the legal team on September 30th of 2016. At an unspecified point during the summer, the case was withdrawn and refiled on the 30th with a powerful addition to the team that was even acknowledged in an article. On October the 10th, Law.com published an article called New Firepower and Shocking Suit Against Trump by Jenna Green. Florida criminal defense attorney J. Cheney Mason, who became famous for successfully defending Casey Anthony, had filed papers to represent Jane Doe. The article stated, suddenly it's a lot more serious, and continuing on to say that the odds the case will go away quietly just got much slimmer. On October the 1st, the very next day after the September 30 refiling, Darren K. Indyke, who was both a Trump Organization executive as well as Epstein's personal attorney, emailed Jeffrey Epstein a link to the Law News article, Donald Trump lawsuit refiled with new witness, which also doubled as the subject of the email, along with it being marked high importance. 3 weeks later, on October the 21st, 2016, Epstein forwarded to an attorney, Reed Weingarten, additional coverage by Guardian. Trump lawyers given court date over lawsuit alleging of 13-year-old. Moving on to phase 4, the dismissal of the case 4 days before the 2016 election. On November the 4th, attorney Thomas Meagher filed a notice of voluntary dismissal under the Federal Rules of Civil Procedure, dismissing the case against all defendants. In an immediate response to receiving the notice from the ECF system, Epstein forwarded the email to his entire inner circle, sending it to Kathy Rumler with the subject, "Told you," and to others with, "Told you the case was fake." So why was the case dropped by the plaintiff just before the election and after fighting so hard to get where she had with the case? Well, to quote the files, numerous threats. A document from the House Oversight Committee records compiling several accusations against Trump says specifically why the lawsuit was dropped. Quote, the lawsuit was dropped in November 2016, just 4 days before the election, with Jane Doe's attorney citing numerous threats against her. And it goes on to say that immediately following this, defendant Trump threatened me that, were I ever to reveal any of the details of defendant Trump's sexual and physical abuse of me, my family and I would be physically harmed, if not killed. So what did the documents show, and what do they not show? Well, though we have documentation of threats being made, the corpus doesn't contain a first-person recording of what the actual threats were, as we don't have the actual withdrawal motion, which is slightly odd, though there are millions of missing files that haven't been released. So it is to be expected. No evidence confirms exactly who, if anyone, communicated the threats. Though Epstein's reaction stating, quote, "told you the case was a fake," show either confidence in either the falseness of the allegations or his confidence in his ability to beat them. That does not, however, constitute a judicial finding of innocence. However, I believe what they do say speaks much louder. First, the 3 separate federal filings show that the plaintiff was persistent, refiling in different jurisdictions, and escalating legal firepower each time and driving harder and harder for results, and then suddenly drops the case. Second, Epstein's real-time monitoring of the situation. He and his legal circle tracked the case from the day Reuters inquired about it to almost the hour it was concluded. This shows he was very concerned with the proceedings, even though he made a showing he wasn't worried, even sending "told you so" emails. Third, it shows Darren Indyke as the bridge linking Epstein and Trump, not only as defendants, but this individual behind the scenes of the case with deep connections to both. Indyke was a Trump Organization executive who was simultaneously Epstein's personal attorney. He forwarded the refiling to Epstein the day after it happened. This is a massive red flag directly connecting the two, even though they supposedly no longer had a relationship. Fourth, the proximity to the election is undisputed. As records show, the voluntary dismissal was filed on November the 4th, 2016. Election day was November the 8th, 2016, and indicates that the situation would have been escalating as things got closer to the election. Fifth, threats were cited as the reason for dropping the case. We have at least one document in the corpus stating that Jane Doe's attorney cited numerous threats as the cause. Though these charges were dropped, the conviction with which this individual pursued her justice was astounding. And for her to abruptly drop charges under fear of threats days before the election in 2016 strikes me as exceptionally suspicious, and more so, completely unsurprising. It is inconceivable that we are at a point where it is unsurprising that the President of the United States is accused of not only and assaulting an underage girl with his best friend Jeffrey, but that she claims to have been threatened to a point where after everything she had gone through to bring this to court, she drops the case. That this is yet another in a long line of strikingly similar accusations. The fact is, some of the accusations in the files are bound to be false. However, the sheer volume of accusations against the same person, matching accusations about similar victims spanning decades, this is the exact reason that charges were brought against Jeffrey Epstein. It is a complete miscarriage of not only justice, but the American legal system and the laws on which it claims to stand. Nothing has been done to investigate countless accusations across these files, some of the most significant of which are about the President of the United States of America. Jeffrey Epstein and his partner Ghislaine Maxwell ran the biggest trafficking ring in the world, yet not one charge has been brought against the people that did business with him, his clients, the people who exchanged millions of dollars with Epstein with absolutely no reason given. They have not even started an investigation and have even openly stated that this is over and no more charges or investigations will occur. Is that the America that you want to live in? Is it the America you want your children to live in? Thank you so much for your time. Thank you to my subscribers, my followers, my patrons. I couldn't do any of this without all of you. And to the rest of you, thank you for watching and for your support. Don't forget to like and subscribe and all of that. If you wish to grab some merch, join the Patreon, or support my channel in any other way, the links are in the description. Remember that if we don't come together, we will fall apart. Stand up and be counted.